So we're moving from vaccination mandatory for everybody to an operationally oriented vaccination policy.
We have lots of documentary evidence that clearly shows that this was something that came down from the Prime Minister's office. And this is why we say it's an unlawful order, because he can't take an order from the Prime Minister or from the Prime Minister's office or the Privy Council. That's not where his commands come from.
As some of you likely already heard, federal court judge Catherine Cowlan, based in Alberta, has sided with the Government of Canada by dismissing a Canadian Armed Forces vaccine mandate lawsuit brought on by 330 plaintiffs who are present and former members of the CAF. The plaintiffs, both vaccinated and unvaccinated, allege that their superiors abused their power and authority, as well as infringed upon their rights when rolling out its coercive and experimental COVID jab mandate. The decision to decide with the government's motion to strike the case and leave the plaintiffs collectively on the hook to pay just over $5,000 in costs was handed down last week. And joining me today to talk about it and let the people know that the battle isn't over yet is Valor Law counsel for the plaintiffs, Catherine Christensen, and one of the 330 she represented, James Formosa.
We feel that there are grounds for an appeal. So we are at this point doing our research and looking up, because she's got some facts wrong and she's got some law wrong, in our opinion. So it looks like my clients they're kind of deciding right now. We had a big meeting last night, and it looks like we may be heading into the Federal Court of Appeal.
Now, there's over 300 plaintiffs this time around. Is that the same group, you think, that would go ahead with an appeal? I know it might be too early to answer, but...
Yes, from the sounds of things, from what the clients are telling me, they all want to proceed, stay as a group, and move forward and do the appeal.
Now, you say that the judge has some facts wrong and maybe even some law wrong. I'm just going to go over a couple of the things here. Basically, it was tossed for the accusation or the finding that it is vexatious. What do you make of that?
I'm finding that it's actually the new hot term for the Canadian Armed Forces and the Department of National Defence, to use the word vexatious. That is basically to put people off, that word. It's to say that you're being bad and you are bringing unnecessary claims before the court, and it's meant to intimidate people. I dispute that what we said in the statement of claim was vexatious, because in my mind, we spoke the truth. The stated facts were all from people who had experienced those things, or it was from documents such as briefing notes, emails, all kinds of documents that we had through access to information requests. So I don't see facts that we can prove as vexatious.
So for my part, my career was going fairly smoothly since my enrollment. I joined the Canadian Armed Forces in April of 2017. I initially joined as an infantry officer. After recovering from some injuries in training, I did component transfer into the artillery. And at the time of a lot of the issues that were occurring that led to things such as the CDS directives, the mandates, and then the eventual 5F release of folks like myself and many others, a lot of whom are part of this lawsuit. I was a troop commander at the 1st Regiment Royal Canadian Horse Artillery in Shiloh. So until those sort of moves, let's say, took place, my career was going well. I was really, frankly, just getting started to my career. I was released in the 5th year of my initial 9-year contract, and I would have signed up for another 20 to 25-year term to make a lifelong career of the profession of arms. However, for my experience anyway, I was shocked to see the direction that the military was taking. I did take a principled stand in terms of my own personal beliefs, and I found myself in a constant state of surprise that for my part anyway, I did submit a religious accommodation request during the implementation of the directives, and I spent the latter part of the final year to year and a half of my career explaining and defending my religious beliefs to my superiors, to the chaplain general, to the grievance committee, and it seemed to fall on deaf ears. Now, I wasn't making any vast, very well thought out theological statements. I just have my certain particular sincere beliefs, and I think that I'm morally obligated to act accordingly, and that I'd be doing something wrong if I didn't live that way. Now, even in seeing the decision here for the most recent developments with the lawsuit, I noticed that the judge made mention of folks who submitted religious accommodations never made particular reference to what their beliefs were, or they couldn't tie it to something that they seem to get stuck on the particulars. However, I know from having to do a lot of this research and defending myself that built into the current orders and directives in the military, a member merely needs to prove sincere personal belief. They do not have to tie their beliefs to another authority. You don't have to agree with the Pope, even if you're Catholic, as an example. For my part, as a Christian, I just described my belief in the truth of the Scriptures, and that I have to live according to what they say and what I think they say about the nature of my conscience and the Holy Spirit. And if I am compelled through prayer and meditation and my relationship with God, if I believe I must act a certain way and I'm being ordered to go against my conscience, that's a conflict, and I believe there's reasonable grounds to be accommodated for that. Nevertheless, none of my arguments were ever meaningfully engaged by the chain of command. I was removed from my unit where I was a troop commander. Usually I was responsible for between 30 to 50 soldiers underneath my command in an artillery battery, or artillery troop, I should say, 3 of the 777 howitzers. They moved me to the headquarters battery, where I was given a small sort of broom closet office and kept away from the other troops for my mere transgressions as well of telling folks things like the fact that choosing whether or not to take a certain medical treatment was a matter of informed personal consent. It was a choice that they could only make for themselves and that nobody could make for them. And that was that kind of principle about our personal sanctity and bodily autonomy is kind of what we're here to do in the first place. Like, I was asking those very dangerous questions about what we're supposed to even be here defending by wearing the uniform, and that includes some of the principles upon which I think the country was founded. Like myself, who were denied our religious accommodation and removed from the military, while we still have some members that are currently serving in the forces, facing persecution daily by still being there, and they have not elected to take certain medical treatments, yet they are still in the forces. So some people have been able to keep their careers and other people have not.
I want to go back to you just briefly, James, to get your opinion when you see a federal judge come out and say that this is vexatious, there's no merit to sort of your plaintiff's testimonies. How does that feel to you?
Well, it does feel, frankly, disrespectful in terms of its general dismissiveness. It's, I can't help but think that this terminology has been carefully crafted to prevent deeper analysis of the actual particulars of the case. So the reason why something like this is used is because it does sound very official and very proper, but it's really a purple prose way of saying, I don't want to talk about these things because it makes me look really bad, and I'm afraid that more people will know what's going on if we actually get into this. I know I'm just paraphrasing here, but it does seem to be the general tactic that they've been using to avoid having to actually discuss it. I know from my own personal experience, especially in dealing with the accommodation process, my constant frustration and dismay in having to defend myself to these superiors was in telling them, this is what I believe and why, and have none of the points that I actually made ever be meaningfully engaged. It is you have to almost admire the the tactics of it all, but it has a tactical advantage, but not a moral one, because it's entirely devised to circumvent actually looking at what the real issues are, what's being brought up, even in terms of our own evidence and our own arguments, because it's a lot easier, frankly, for the Crown to dismiss things out of hand, because it would be incredibly damaging to them if they actually had to engage with any of the evidence or arguments or clear examples that we can provide them to explain the nature of the wrongdoing. They don't want to touch it.
Some of the things that the judge pointed out in her reasoning, she said that some of the arguments constitute an abuse of process. She also pointed out things and said that they weren't based on facts. For example, referring to the COVID jabs as being experimental and a gene therapy. Knowing that that was something she was going to latch on, would you be doing anything differently in that area, or what's your thoughts of her pointing that out?
First of all, the reason that we even used that language was because the lawsuit was not actually about the mRNA vaccine jabs, whatever you want to call it, because it was all about abuse of power. And the example was the mandated injections for everybody. So that use of language was kind of deliberate in order to take away so that there wasn't this COVID vaccine throughout the statement of claim. And the other thing, my other thought about it was during the hearing, the Crown lawyer kept saying that we were conspiracy theorists and that this was all fantasy. So I'm not surprised that she latched onto that in language. I would say time has borne me out, because we filed that in June of 2023, and now you are seeing scientists with all the credentials come out and call it experimental, gene therapy, etc. All the language that was used is now commonplace in the vernacular. So could I have changed it? Yes. If I was to have to rewrite the statement of claim, perhaps I would change the language just so that it takes it off the table as an excuse. Because I have to tell you that the lawyer who represented the postal workers in a lawsuit against the COVID mandates, he actually pointed out that his judgment from the same Justice Conklin, are almost identical. The wording is identical, the decision's the same, even the costs award at the end is exactly the same dollar amount. So, and it came out, this decision came out very fast. We've submitted over 6,000 pages of evidence. There's no way that got seen in 2 months. For her to say, I'm not going to, I disregard it. It's this evidence, I'm not going to take it into account. I don't see how she could have read it in 2 months.
Can you tell us a little bit about who the actual command might have come from and why that's an issue?
So, interestingly enough, General Eyre, who was acting Chief of Defense Staff in August of 2021, came out and publicly and was adamant that there would not be a mandate for COVID vaccine in the Canadian Armed Forces. He was very clear that was not going to happen. And then on October 8th, he brings in exactly that, a mandate, to say that it's going to happen. Now, we have emails that show that the order, if you will, came from above General Eyre. Now, how the chain of command works is that General Eyre does not take his orders from the Prime Minister's office. He takes his orders from the Governor General or the King. And I don't think the Governor General or the King gave him instructions. We have lots of documentary evidence that clearly shows that this was something that came down from the Prime Minister's office. And this is why we say it's an unlawful order, because he can't take an order from the Prime Minister or from the Prime Minister's office or the Privy Council. That's not where his commands come from.
So how do we get to the bottom of that?
If we are not able to present our evidence in court, then we move in a court of law, then we move into the court of public opinion. And we start releasing all of this information that we have because it's all been obtained through access to information requests. So it's public record. And my clients are prepared to start releasing. They have over 600,000 pages of evidence to show what happened and the corruption within the Canadian Armed Forces on just this one issue. There are more issues that has more evidence in my files, but to this particular one, if we're not going to be allowed to bring it into a courtroom, then we will bring it into the court of public opinion. And I am encouraging everyone to become more politically active. I think our neighbors to the south very clearly showed that the people hold the power, and people can, if the people are determined to change things, it can be changed. Because if the courts won't find that there's fault, then we need Parliament to change the law. Because the grievance system that we were told in this judgment that works so well does not work. It does not work well. And we basically had the court saying that it's okay to physically torture your troops. It's okay to harass pregnant women. Men in uniform can come and harass a pregnant woman. A young woman can be put into a room with 4 male superior officers and be ordered to do something she doesn't want to do. That's what this decision says. That's okay. That's fine. And that's not the Canada I want to live in.
Tired of big pharma over people benefiting policies being handed down by our health officials? Then join close to 50,000 others at our special website called nomoreshots.ca to demand that Canada's health minister take COVID-19 jabs off the market until we all truly trust that they're safe and effective.